All right. Hi, I'm Gus Nelson. I'll be taking you through the negotiations course this semester. Uh, Let me just go through a couple of administrative matters before we get rolling. First, let me introduce myself. I am an attorney of 25 years plus experience, mostly as an insurance defense attorney. I've done a lot of negotiating over the years, and so I do have some practical experience. This isn't just me trying to teach you, I've also done it. Um, some of what I will try to do with those of you who are law students in particular is give you some practical advice beyond just simply negotiating, because a number of the things that we learn in this course really translate into broader principles, just how to handle yourself as an attorney. Uh, the principles that apply, though, whether you're a lawyer or not, are going to be helpful. If you're just taking this course as a matter of business negotiation, it will still help you. There'll just be a little law thrown in, so if you're dealing with lawyers, you'll know what they're up against or what they're dealing with. And if you're dealing with your own attorney, you'll maybe have some insight into what that attorney is or isn't thinking. The format of the course is outlined in the syllabus. I won't spend a lot of time on that. If you don't have the book yet, don't worry. Much of the response that I will want from you will come from the lectures, particularly this beginning part, because it's more of an overview. As we get into the lectures, the chapters, you'll see the need for the book more. The book is Gifford, Donald Gifford, Legal Negotiation, and that's the required text. The recommended text is Getting to Yes by Fisher and Urey. That's a decent book. It's got some cool stuff in it, frankly, that I like. I don't require you to read it because they think that they've come up with the solution to all possible negotiating problems, and I don't agree with them, and so I don't require the book, but I do think it has lots of good stuff in it. So it's a paperback. It's probably $5 or $10, if that. You might find it on Amazon for $3 at this point. I don't know, $2. If you want to get it, get it. It's worth getting. If you have the resources to get it, it's worth getting and reviewing and reading. You'll notice in the syllabus that the last several weeks of the course, all we're doing is negotiating. There are no tests in this course. There will be feedback from you from time to time. Particularly, there will be, after each lecture, a review session, so to speak, in which I will ask you some questions and want you to respond in writing to me. So that will effectively be, I guess, quizzes along the way. But I'm not really going to give any specific quizzes or tests in the sense of black letter testing. I'm just not going to do that. So that may be good for you, maybe not, I don't know. All right, let's jump into the material. Some things you need to know at the outset. First, I don't care what background you're coming from. I don't care how smart you are. I don't care how gifted you are at negotiating. It doesn't really matter. If you're willing to spend some time and think about these principles, then you can become an effective negotiator. You may not, be the greatest negotiator ever, but you can do it effectively and efficiently and reasonably well if you're willing to apply yourself. It is a learned skill. It is not an art form. It really isn't. It's something you can learn to do, and much of it is, quite frankly, is common sense in a way, and oftentimes you'll scratch your head and say, gosh, I can't believe that's coming out of the professor's mouth. I mean, it just makes sense to me. I think that'll happen to you frequently, and you'll think, well, why in the world am I taking the class? Well, the reason you're taking the class is because oftentimes you're not going to think of it in the sort of that comprehensive way that you would if you don't take a class like this. So it's helpful to kind of get it organized in your mind. Frankly, much of doing a thorough and reasonable and effective negotiation has to do with your preparation and planning as it does with the actual negotiating. So that's just as much a part of it, and maybe even more so than the actual negotiation. If you've gotten yourself organized and together, you're probably going to do a reasonably good job negotiating, even if you aren't the most articulate or even if you aren't the most savvy deal maker, and you're still okay. Let me give you some very quick basics, and forgive me, as you notice, I will be looking to the side from time to time. I have notes sitting here on my desk at home, and so you'll see me looking at those from time to time. That's what I'm doing. I also often like to drink coffee, and so you may see me take a swig from my coffee cup from time to time. Forgive me for that in advance. Negotiation is basically just a process where you are trying to relieve tension of some sort. Now, it may be very, very significant tension, even hostility, or it may be simply the tension of a business deal where the negotiating parties want to come up with some resolution, and they don't really have a problem, to put it in quotes. They just want to come together. And so but there's always tension no matter what. I don't care how happy everyone is to try to make a deal. There's always going to be tension. And as a result of that tension, the process is designed to relieve it and come up with a solution that isn't forced on anyone. From a legal standpoint, there's a couple of rules to keep in mind, you upcoming lawyers. Rule 1.2, which has to do with the relationship between the attorney and client in terms of who gets to do what and who gets to say what about what. In other words, the lawyer does not control the ends or the objectives, but the lawyer may, and to a great extent, control the means of negotiating. And so we'll talk about that more as we go along. You've got to know your client and particularly your client's risk tolerance. That's a very important theme you'll hear from me more than once. You've got to understand where your client's coming from and why they want what they want and what they're willing to give away or give up or deal with to get it. Finally, as lawyers, those of you who will be lawyers, and even those of you who won't, maybe this will give you some insight into some tension that lawyers often feel. There's a difficulty between dealing with the system at large, which lawyers have a duty to the legal system, so to speak, and a duty to the client. And so the question becomes, which one, gets the balance, and how do you balance that out so that you get a reasonable resolution of that tension for the attorney? Sometimes it may seem like you're selling your client out because you have to go a particular route because that's the legal route you have to take, and clients don't always understand that. So that's a tension you'll have to think about and you'll have to deal with from time to time as you negotiate. I mean, that's something you'll have to deal with as an attorney all the time, just dealing with clients generally. All right, chapter 1 of Gifford talks kind of about the basics, and so let's talk about some basics. One, I said you got to know your client. What are the parameters of the negotiation? What are your client's expectations? That's a very important thing you're going to need to know. Are the expectations realistic, or are they out of this world? Is your client a risk taker or a risk avoider? And those are things you're going to want to ask. And how do you figure that out? Look, one of Nelson's rules of negotiation: questions unasked are questions unanswered. You will hear me say that again and again. That goes both with your client, asking your client questions, and asking the other side questions. If you have a question, you better ask it. And you need to get answers to those questions that you have, because it's going to affect how you negotiate, whether you can negotiate, and what you can negotiate in satisfying your client's needs. It's very important. Even if you're negotiating for yourself, you may need to ask yourself those same questions. So keep that. Questions unasked are questions unanswered. Now, is that the dumbest coffee mug you've ever seen? Yes, it is. Got to keep your client informed. That's model rule 1.4. You've got to maintain communication. Let me tell you again, as a general matter, as a practical matter, this is one of the biggest things that gets lawyers into trouble, is they don't stay in touch with their client, whether it's a negotiation or otherwise. Something else to keep in mind: one session negotiations almost never happen. It's very unusual, unless it's something where you just sit down for hours and crank something out. And that's pretty atypical. It's very normal to have multiple sessions. And by sessions, I could mean the exchange of emails. 2-line emails could be a session if you want to call it that in terms of negotiating. It's usually a process that goes on for a period of time. It's rare for anything, even the most simple case or the most simple situation, to get resolved in one brief face-to-face discussion. Sometimes it does happen, but that's unusual. There are three basic strategies, and you'll see this in Gifford throughout, and he likes to use these three. One of them is competitive, the second is cooperative, and the third is problem solving. If you're like me, you're going to see a lot of similarity between cooperative and problem solving, and I don't think, frankly, Gifford does a super job of really clarifying what the big differences are between the two. Competitive usually is when you have a zero-sum situation. That's what I dealt with as an insurance defense attorney for years, negotiating with plaintiffs' attorneys about resolution of cases. The insurance company had money, and the plaintiff wanted the money. And the question was, how much money was the plaintiff going to get? And it was that simple. If the plaintiff got $1, the insurance company gave away $1. If the plaintiff got 20, the insurance company gave away 20, and so forth. It's a zero-sum game. That's usually often very competitive. The plaintiff starts high, the defense starts low, and all that kind of stuff. Cooperative is usually more, and this is old, so some of you won't maybe get the reference, but there's an old TV show called Let's Make a Deal. Maybe that's still on. It's an old game show, and there was a guy named Monty Hall who was the host of that show, and it was a show where the question was, do you want what you have in your hand, or do you want what's behind door number 1? And the idea is that in cooperative negotiations, we're trying to make a deal. Everybody wants a deal, and we're trying to get a reasonable, fair solution to the problem, something like that. Problem solving, I guess you could say that's something like, well, we're going to reason together. Cooperative negotiations still have a sense of back and forth, whereas problem-solving negotiations perhaps have more of a sense of joint venture. So cooperative negotiations, everybody kind of is on board, but still kind of there's some back and forth. Maybe a problem-solving negotiation, everybody's kind of pushing in the same direction. I guess that's the distinction. Here's the thing to note, though. You may use all these strategies in one negotiation. It's very possible. And so that's something to keep in mind as we go forward and as you're thinking about it. What are the components of the process? To the extent, and again, keep in mind, the whole thing with negotiations is it is a very fluid process, a very amorphous process. It's very difficult to say these are the 3 rules of negotiating and then just follow them strictly and you always do fine. It doesn't work that way. There are people involved in negotiating. There are constituencies involved in negotiating. And as a result of that, it's never easy and it's never simple and it's never cut and dry. And you can't follow the 4 rules of negotiating and get it done. It just doesn't work that way. So whenever I talk about these things, you need to keep in mind that these are sort of like firm guidelines would be a good way to put it, and not rules. I'm very fond of George Orwell's essay, Politics in the English Language, in which he describes his rules for writing well, and then in the very end, sorry to alert you if you haven't read it, but at the very end he basically says, look, break all the other rules I just gave you if it will make your writing better. Same thing with negotiations. All right, I'm going to say a lot of things this semester. Break every single one of the rules I'm giving you, these rules that I'm giving you, if it'll make the negotiation work well. So what are the components of the process? You start off with planning and preparation, generally speaking. What strategies will you use? What information do you have on hand to start with? What do you need? What information do you think you can successfully give out, at least initially? The ground rules, are there any? Have you made up ground rules? Is it the kind of negotiation that requires some negotiation about how you're going to negotiate? So you've got to keep that in mind. Or is it just simply the ground rules are that, like many of the negotiations I did, the ground rules were you're going to start high, I'm going to start low, and then we'll meet in the middle somewhere. Initial proposals, who breaks the ice with an initial offer or an initial opening salvo, whatever kind it might be, who breaks the ice and why. Information exchange is the next part of the process. The parties go back and forth. There's discussion about evaluations. There's discussion about information that's pertinent to the negotiation. What does that information mean? What's each party's take on it? For me, most of my life spent practicing law in Virginia. I often had discussions about, say, contributory negligence. Did I think the plaintiff was contrib? How did that impact the negotiation? Did I think a jury would take account of it and give the plaintiff a pass, or did I think the jury was going to really push hard on the plaintiff and maybe even find against them if we went to trial? So that might be something we would discuss. Narrowing differences, that's when you've gone through sort of the beginning, you've maybe had some back and forth, you've exchanged some information, maybe some offers and some demands, and have gone back and forth. Now you're at the point where the parties recognize that they may be able to get this puppy done, and so there's a narrowing. How do we get the other side? How do we funnel this down into a resolution? Finally, closure. What are the last things we need to do to absolutely make sure the deal gets done? Now, it kind of gives you an outline of the process. Issues peculiar to lawyers. I've already mentioned this briefly. I'll just quickly mention them. Rule 1.2 of the model rules regards who has control of what phases of the negotiation. The client always, always, always determines whether to settle or not, whether to accept an offer or not. So the client always determines the objective. The lawyer, of course, in consultation with the attorney, you would hope, but the client always determines the objective. The lawyer does have some control over the means, and I would argue, personally, I think that the lawyer has a great deal of control over the means and ought to assert a great deal of control over the means of the negotiation if the lawyer's involved in it. If the lawyer's not going to be involved in the negotiation, then there's no need to be involved, period. You're going to find yourself in difficult circumstances as an attorney if you're sort of half in and half out. You need to have some clear-cut authority and understanding of what your role is if you're an attorney. Model Rule 1.4, I mentioned a moment ago, has to do with communication. I've already mentioned that. I'm not going to say anything more about it. Rule 4.1 relates to others who are not involved. If you're an attorney in particular and you're dealing with someone who's not an attorney, you have a duty to be honest with people. And in particular, if you're a Virginia attorney, unless Virginia has changed its rule in the past several years, Virginia's rule was a little bit tougher, I think, than the model rules in terms of this requirement. Now, I'll talk about that later on. Are there rules of legal etiquette that require the lawyer to observe certain informal guidelines that are in the legal community? This may be true if you're a real estate agent and you have a community of agents where you live that you deal with. It's probably the same thing. There's certain things that you do and you just don't do. If you're negotiating a sale of a house, it's probably different than the sale of a business. Maybe, maybe not, but it probably is. And there are certain guidelines or norms within the negotiating community that you're a part of that you're going to have to observe. These are unwritten rules, if you will, that you can only learn either by trial and error or by asking. And remember that Nelson's rule of negotiations, questions unasked or questions unanswered. Gifford talks about game theory. I'm not going to spend any time discussing game theory except to say that it's an interesting exercise. If you're not familiar with game theory, just read that portion of Gifford's book when you get the book, and you'll see what I'm talking about. Game theory is often referred to as the prisoner's dilemma, and this is the problem where you have two prisoners, and the outcome for each prisoner is best if they don't confess to a crime. But the problem is that the police are using each one against the other, and it turns out that if both prisoner A and prisoner B fail to confess, then they both walk away, for instance. They both get off scot-free. but the odds are, and both prisoners know it, that one of the other is likely to confess. If they both confess, the outcome for them is the worst possible outcome. And so the best outcome from the most likely outcome is one confesses and one doesn't, and the one who fails to confess gets more time in the slammer than the one who confesses. And so it describes some of the problems and tensions that you have to deal with in negotiations. It's worth looking at when you get the book, but it's just something to consider and think about as you look at negotiating. Here, the problem with the prisoner's dilemma is it assumes an underlying rationality that I have not observed among my fellow human beings as being the norm. So that's the difficulty with it. Judgment, quite frankly, is something you're going to have to use regularly in negotiations. Idle chit-chat, frankly, before a negotiation can be very important. If you're getting ready to negotiate and you just happen to be meeting the other attorney and you just get into some brief discussion about sports, and the other attorney indicates, I've got my Virginia Tech tie on. I went to Virginia Tech as an undergrad. That may indicate something about me, that I really like Virginia Tech. And you may then pick up on that and use that as, for whatever reason. It's information that may or may not prove useful, but it may give you some insight into something about me. Maybe, maybe not, but it's this kind of thing that you need to sort of just be alert. You're going to have to, though, learn your own strengths and weaknesses as well as those of the person or persons with whom you're negotiating. What are you best at? What do you like? What kind of things do you like doing? Are you a person who would curl up in bed and read a book all day, or are you someone who'd rather go out and play a game of rugby? You need to, analyze that and then use those characteristics about yourself that you know, and use your strengths as best you can, and come to understand your own weaknesses and whatever they are. And when you are dealing with the negotiation, you'll know when to cater to your strengths and when you're going to have to worry about your weaknesses. So just kind of keep those things in mind as you go along. What are tactics? Tactics are specific behaviors rather than strategies. Strategy is kind of the overall plan. Tactics are specific behaviors designed to deal with specific circumstances. Style is the negotiator's bundle of traits, whatever that is. You may be very gregarious and therefore easy to talk to, and you may be really a great listener and easy to talk to or easy to talk with. Again, those are things you need to know about who you are and what you are, and exploit them. All right. Let's talk a little bit about tactics. All right, I've just kind of given you a very broad overview of negotiating there in a few minutes. Let's talk about tactics for a few minutes. Tactics are, as I said, specific behaviors. Strategies, and we'll talk about strategies as well, are a series of tactics, or a broader overview of what you're doing. There's different types of strategies that you can employ, and again, these might be employed as an overall strategy, but you might shift strategies during any particular negotiation depending on where the negotiation is leading. Integrative strategies suggest that both sides can gain something as a result of the negotiation. Maybe you're doing some kind of business deal. It could be a corporate buyout. It could be a purchase of equipment. It could be a lease of premises, of real estate. It could be any number of things in which there's some potential for everybody to be satisfied. Distributive, that's really more a matter of what I did oftentimes over the years in the insurance business, where what one person gets, the other person has to give. Those kinds of negotiations, knowing which one you're going into, may affect how you decide your strategy and your tactics. So you have to know, what are we doing here? One of the other things you need to think about is your relationship with other negotiators, okay, when you're deciding what strategies and tactics to use. If you are in an area or in a field where you're going to have repeat contact with people, then I would suggest to you strongly that you very carefully think about whether you're going to go in with a full-blown competitive, no holds barred, I'm going to crush you kind of negotiation. If you're going to see that person next week and have to negotiate with them again, that's probably not your best strategy. You probably want to take a more cooperative approach. It doesn't mean that your tactics won't be competitive, but it does mean that you will have a cooperative, a competitive underbelly to it, but a cooperative approach. For instance, you might take a very friendly attitude and sort of behave in a manner that is very cooperative, at least seemingly, but you are using a very competitive dynamic in terms of your way of handling it, in terms of your offers. For instance, I might say, yeah, I understand what your client needs. I get that your client is looking to hit a home run and is looking to get $1 million in this case, but you've got some problems with it. I understand that your client does have some very serious injuries, and I understand that your client is in need of medical treatment. I understand all those things. Here's the problem. Your client ran a stop sign, and that's a difficulty for us. That doesn't mean we can't get to some resolution, but it's a difficulty we're going to have to figure out, a way to resolve this and taking that into account. I've said nothing about an offer. I've said nothing about giving the other side any money. At that point, I've simply said, and I've tried to be very gentle. So I'm not being competitive in my attitude, but I am being competitive in what I'm saying, and that is basically I'm saying, look, we may be in a position to give you very little because your client ran a stop sign. So that's what I'm talking about when I say competitive and cooperative. You might use cooperative tactics in a competitive situation, for instance. Let me give you some more details now that flesh out what these things look like. Competitive strategy generally tends to produce an adversarial relationship. The parties are kind of going at it. It attempts to undermine the other negotiator's position oftentimes. The other party is often seen as the opponent rather than as someone we're working with. Usually the competitive strategy seeks the most advantageous resolution for the client, kind of almost regardless of what the other side wants. May not be concerned about the relationship at all, especially if it's a one-shot deal. If you know you're never going to see this person again, then it may be a time to use a competitive strategy. Cooperative strategy usually seeks a fair and just resolution. I don't like the word fair. I think it's a word that's difficult to get your arms around, particularly in the law. But it's about as good a word as we can use here. You'll hear that spoken. We just want to get a fair resolution. We just want to get a fair result. And that may signal that someone's trying to be cooperative. People often seek to obtain goodwill. Again, if you're going to have multiple negotiations, oftentimes you'll use cooperative strategy and cooperative tactics. Often initiates concessions if you're using a cooperative strategy. That is, you'll start the concessions. Yeah, I'll go ahead and give on that. And as we go along, we'll talk about when is that a good idea, when is it not, why might it be a good idea, and so forth. There's a concern for the relationship involved. And here's what's interesting, and Gifford suggests this in the book, and you'll get to this. There's a prevalence of cooperative tactics among practicing lawyers, even in the distributive context. That is, even in the context that I've discussed previously, where if I give you something, you're getting something, and it's a zero-sum game, so to speak. Even then, there's still an overwhelming urge to cooperate, especially among attorneys who know they'll see each other repeatedly. I can attest to this, having been involved in the personal injury game from the defense side, where I saw the same attorneys again and again and again, and we got to know each other. And quite frankly, there came a point where we kind of learned each other's weaknesses and strengths, and we're able to frankly cut to the chase oftentimes and get things done fairly expeditiously and reasonably because we cooperated knowing each other fairly well. Problem solving just usually means you're working together and trying to obtain as much mutual gain as you can. Now, let's talk a little bit about style. Even when the substance of the negotiation is competitive, style, cooperative, using a cooperative style, as I just showed a minute ago, often helps to smooth things over. There's an old saying, it's not really true, but it sounds good, and that is you get more flies with honey than you do with vinegar. I understand from doing some research, the truth is you get more flies with vinegar, but be that as it may, the saying goes that you get more flies with honey. And look, again, practical tip, and this doesn't apply to negotiating per se, but it's an example that makes what I'm going to say make sense. If you're an attorney and you do litigation, as I've done for many, many years, you will be in clerks' offices all the time, court clerks' offices. And probably one of the best friends you can ever make is the court clerk, or clerks usually, and getting to know them and getting to know who they are and chatting with them and just being decent with them. Let me tell you, it takes you a long, long way. And so that's what I mean by you get more flies with honey than vinegar. It will serve you well to be polite. It will serve you well to be, mannerly. Those are not signs of weakness. Those are signs of a person who's just got the right disposition. You don't have to be an overbearing jerk in order to be a good negotiator. You just don't. And my mom is a beautiful example of that. She's one of the most simple, and I don't mean simple-minded. She's just a simple person, has simple taste, and is very good at saying no and no thank you, very politely, but she's very good at it. And you're not going to push her over the edge if she doesn't want to be. But she'll never be angry. She'll never scream and yell. She'll just politely say no thank you. So keep that in mind. Law students in particular. You learn from the beginning of law school that case law is very, very important. And it is in analyzing the law, of course, because that's the common law is a big part of what we do in the law practice. Here's the problem, though. Law students are taught from the beginning of law school oftentimes that it is important to learn how to argue a case. And you must be able to do that, yes. But when you're negotiating, it's not the same as arguing. And you have to try to almost divide your mind, if you will, and understand that you're not going to argue everything when you're negotiating. It's not an argument. It's a negotiation. And sometimes you're going to have to set aside the gifted litigator and put instead in that person's place the gifted negotiator and tone down the arguing. There is a place for argument in negotiation, which we'll discuss, but that's not primarily what you'll be doing. You have to use judgment and common sense throughout. I mean, that just sounds stupid, I guess, or maybe self-evident, but not always so much. You always need to exercise judgment and common sense. If something sounds reasonable, then it probably is reasonable, especially if you're prepared. So use your common sense, use your judgment. If you're not sure, ask someone what they think. Ask if you're in a firm with multiple attorneys, obviously ask around, see what people think. Get back and forth with your client, particularly if your client is someone whose judgment you think is reasonable. Sometimes you'll have clients who aren't, but that's another problem we'll deal with as we go on. What about specific tactics? How do you know? How do you know what tactics to use, and how do you know when to use them? Good question. And the answer is, I don't know. I mean, I don't know because I don't know the specific situation. Again, this is it, you have to sort of you have to know your client. You have to know the situation. You're going to have to start with a plan and then be ready to adjust as you go along, depending on what you find out. And it's vague, and I wish I could give you some hard. Again, there's no hard fast rules here. You just have to understand that the process will always fluctuate some. And so what you have to be able to do is have parameters that you sort of know what those parameters are. You have to know the specifics of what you want. What does your client want? Why does your client want what they want? And is it reasonable for your client to want what they want? And once you've kind of figured all that out, and we'll talk about bottom lines, we'll talk about the term BATNA, B-A-T-N-A, best alternative to a negotiated agreement. And you'll kind of see how this fits in. Right now, we're just sort of, this is still kind of in the overview stage. So how do you know what tactics to employ? All right, well, here's some tips on things you can think about. What is the other side doing? Are they being harsh? Are they being nasty? Are they really being tough? If they are, you then have a choice. You can respond in kind, or you can think about, well, is that the best way to do it? Will I get more flies with that honey than with the vinegar? Again, part of that is reading the situation and coming to some understanding of the situation. Part of that is paying attention to what other people say and why they seem to be saying it and how they're saying it. Sometimes people fake anger, or they fake irritation, or they're acting like they can't possibly take that offer, when really what they're thinking is, wow, I can't believe they made that offer. I could settle it right now, but obviously I'm going to get more out of this, and so I'm going to take them as far as I can. What is the other side's negotiating strategy? Well, what are things you can use to think about what their negotiating strategy is? Well, A, have you negotiated with them before? If so, then you might know something about how they strategize and the tactics they might use. B, what's their reputation if they have one? Lawyers talk, so do judges, so you can find out. Again, in the community in which you practice, everybody has a reputation of some sort or another. As a side note, I would urge you, I can't tell you how much I would urge you, have a reputation for integrity, more so than anything else. Look, I fancy myself a decent litigator. I had plenty of good cases where I got great results, and I had cases where I got the snot kicked out of me. If you try enough cases, those things will happen. I don't think my reputation in the community where I litigated the most was that I was, the greatest trial lawyer ever. But I think my reputation was that if I said it, you could trust me. And that, I'm telling you right now, that makes a great deal more difference to most attorneys than, oh yeah, that guy's really great, but. Because the but is, yeah, but you can't trust anything he says or she says. If that's your reputation, you're going to have a hard time overcoming it. If your reputation is that person can be trusted with anything, he's not the greatest litigator, but you know what? He'll do a good job. You'll take that any day. You'll be a successful attorney. You'll do just fine. If your reputation is you can't be trusted, you won't do well. You may for a while, for a season. Remember that the truth is that most lawyers act cooperatively, so that's another thing you can think about on strategy issues. And remember this too, what are the odds? What are the possibilities? What are the probabilities? You're going to have to come to some understanding of what you think they are, even when you're not completely sure. Part of my job as a defense attorney, as an insurance defense attorney, was to constantly explain to the claims examiners what I thought the odds were of verdicts. What did I think the odds were of a verdict of this level, a level A, level B, level C, level D, and so forth. That's part of what you're going to be doing with your client, is explaining, what do you think? And again, these are not precise scientific measurements here. This is based on experience. It's based on knowing the circumstances. It's based on knowing your client. Let me ask you the following question. If the other side is cooperating, do I take advantage by acting competitively? And here's some possibilities. Yes, because it's always best for my client. Really? Maybe. Yes, because I'll probably get the best result for my client. In this instance, that's a possible answer. They're cooperating. You act competitively. Yes, but only if this is going to be a one-time negotiation and I'll never see this lawyer or his or her client again. That may be an answer. No, because if the other side is cooperating, I ought to cooperate. There's some social norm or norm within the community. No, because it's wrong to take advantage of people. Maybe there's a moral law that's higher than that of simply getting the best possible deal. No, but only if this is a negotiation where I'm going to be seeing these people again and again. Those are possible answers. I'm not saying any one of those answers is necessarily the correct answer, although presumably from my demeanor and from the things I've said already, you can see that I'm going to line up more with the idea that if the other side is cooperating, that gives me a measure of thinking that I probably ought to cooperate. Not necessarily, but that I ought to at least think about it. What is the other side going to do? How do you know this? Is there any way to know it? Well, initial tactics. What are their initial tactics? Are they ridiculous? Does that mean they're going to be ridiculous throughout? Maybe, maybe not. Not necessarily. So the initial tactics are some indicator, but again, you can't take that as the gospel, so to speak. They may take an initial position that is ridiculous and absurd, and you both know it. But then they may very well then later on modify their position. So it may give you some idea and let you take the temperature a little bit of the other side, but it may not be it's not foolproof. Prior negotiations, yes, but I would just say be aware of the wolf in sheep's clothing. There are people who are smart enough to recognize, I've negotiated with this person 3 times. They're going to expect that I'm going to come out both barrels loaded, and so I don't. Or they expect me to come out sort of cooperatively, and so I don't. Let me tell you a little quick story in this vein. There were a law firm that I dealt with on a regular basis that knew me as being a guy who was generally, I'm a cooperative guy. I mean, I don't mind saying so. I was not a guy who would go crazy on people. I wasn't overly tough just for the sake of being tough and being obnoxious. I was the kind of guy who liked to work things out as best I could. Now, if I couldn't, I couldn't. And they knew that if I thought I had a really good case, I would say so. So we go into a negotiation. It was a mediation, a court-ordered mediation, and the plaintiff in this car accident case had a drinking problem. At least it appeared he had a drinking problem, and it appeared to be reasonably well documented in his medical records. And I just really went after this guy about it at the mediation. I looked him right in the eye as we were negotiating, and I pointed my finger at him, and I jabbed a little bit, and I kind of basically said, listen, pal, don't think that we're going to roll over on this. It was a bad accident, and he was claiming that he had some kind of problem thinking and being clear, and that maybe he had lost an opportunity for a promotion that was debatable. And I really went after him hard, which was very unusual for me. Even the mediator who knew me was a little surprised. But I mean, I basically told the guy, listen, I am going to take your medical history. I'm going to put it in front of the jury. I'm going to make you look like a drunken slob. And I'm going to beat you up as hard as I can in front of that jury because this is ridiculous. We've made a good offer, and you need to get serious about this case and take what we're giving you. And I was very harsh on him, which is very unusual. And it really did set the other side back, quite frankly. We ended up settling, and we settled pretty close. I think we put a little bit more money on the case, but it settled pretty close to where we were because it was right. Again, that's not my usual. That wasn't my usual MO, but in that case, I needed to. What would you do if you were the other side? Is always a good question to ask. What would I do if I were them? How would I strategize? What tactics would I consider? That's a good way to get inside their head. This is probably a good way to think about what strategies they're going to use and what tactics the other side is going to use. During stages of a negotiation, you may change your mind about things. Excuse me. When you get to Gifford, you'll find a story about the union negotiation on page 35 and 36 of Gifford. This is the classic, oh, they're leaving money on the table problem. I dealt with that all the time with insurance examiners. They always got worried about putting too much money on the table. We didn't need to offer them that much. Well, then don't offer it. I mean, my answer to that was, well, don't offer it then. But don't offer it and then get aggravated that they took your offer. So don't get caught up in that. If you are negotiating and the other side says, we like your deal, we're going to take it, then shouldn't everyone at that point be at least modestly happy about getting the thing done? There's no pattern. There's no strictly identifiable pattern for negotiations. Different kinds of negotiations do tend towards patterns. Personal injury negotiations tend toward the plaintiff asks for $1 million and really only wants to get $20,000. The defense offers $10 and really wants to give away $15,000. Okay, and so there's always a pattern like that to some extent in different kinds of negotiations. A business deal, the parties are always going to be cautious at the beginning until they realize that it looks like we're going to get together, and then things kind of tumble very quickly at the end. Again, not always, but oftentimes. The beginning of a negotiation, I know I'm going very long here, so forgive me, but I'm doing these 2 chapters. You're going to see the beginning of a negotiation, you'll see some basic orientation, people trying to, like boxers trying to figure out who's going to do what. You'll be kind of circling around a little bit, maybe taking a jab or 2 here or there. Information gathering, everybody will be exploring options, trying to figure out who knows what do they know, how do they know it, what kind of information do you have. This is one of the biggest keys. If there are things that you need to know, again, questions unasked are questions unanswered. If you don't know something that you think is important, you've got to ask. The other side may say, I don't know, I'm not going to tell you. Here's the answer. Here's a partial answer, and we'll get to that in a minute. Particularly, how do you answer questions when you don't want to? We'll talk about that later, another session. But you got to ask if you don't know. The bargaining stage is when everybody gets serious, and then closure, you get the deal done. One thing I will say when talking about competitive and cooperative strategies and tactics, it is typically true that if you start out competitively, you can kind of then ease into cooperation. It's a lot tougher to start out cooperatively and then get competitive. Excuse me, for obvious reasons. It's like a coach of a sports team who starts out soft on the players and kind of takes it easy on them and then toughens up. They hate him. But if he starts out tough and beats on them all the time and is evil and mean and then starts to ease back, suddenly the players kind of feel a little differently. And so same kind of situation here. Relative, we're going to talk about a couple other things and then we'll be done with this first section. So I know this has gone on a long time. Thanks for hanging in there with me. Relative bargaining power. How does that impact things? Does it impact things? Well, yes and no. If you are the relatively weaker bargainer, that is, maybe you are an individual bargaining against a big company, for instance, they're going to have people that are used to doing deals, or they're going to have people who are used to negotiating. Insurance companies, this is a famous thing with insurance companies. Insurance claims examiners negotiate all the time. It's what they do day in, day out, every day for their job. Most ordinary human beings don't negotiate constantly. They do from time to time, and most of them aren't very good at it. Does that give the insurance company an advantage? Well, of course it does. What you have to do as a negotiator is you need to understand that there are going to be situations in which you have the bargaining power and in which you have the weaker position. Exploit that reality, whatever it is. What do you do if you're in the weaker position? And because obviously if you're in the stronger position, it's kind of self-evident what you do. You take advantage of the fact that you're in the stronger position. You use that to your advantage. I mean, you have to. Particularly if you're an attorney representing a client, you have to. It doesn't mean you're mean, it doesn't mean you're ugly, it doesn't mean you're nasty, it doesn't mean you're vindictive, it doesn't mean that you're antagonistic, but it does mean that you work hard for your client to get a good result for your client. And if your client is relatively stronger, then you use that leverage as best you can. But what if you're weaker? Well, two things. One, do you really believe what you're doing? I can tell you from litigation that when I went in with a case that I really believed in, and I could get behind it and get behind the client and really felt comfortable going in and telling a jury, this is so, I did a much better job litigating that case than in a case where I was forced into going to trial because I had disagreements with my claims examiner about the nature of the case or about certain issues or whatever. That made it much tougher. So that's important. Do you really believe in what you're doing? You can't gin that up. That's well, maybe you can, but it's really hard. So do you believe in it? Do you believe in your position? Gifford suggests that the weaker bargainer almost inevitably resorts to cooperative tactics. I'm not sure I think that's necessarily the case, although I think practically it often is the case. I don't think that's not an absolute rule. What do you do if you're in a weaker position? Well, one thing you can do is explain to the other side why you are not as weak as you appear. They may say, you are weak, right? Your position is weak. Well, why isn't it as bad as it appears? What could be an example of this? And I give a lot of examples from my own background, so forgive me. But suppose that you're a small business and you're negotiating a lease with a large organization. One of the things you basically do is you say, look, I'm ready, willing, and able to make a deal with you. And yeah, you may have other people who are allegedly interested in this space, but I'm obviously very interested in this space because I'm here at a negotiating table trying to negotiate a lease with you. So don't try to roll over me thinking you just got it in the bag. Do you want the space leased and get money for it, or do you want it empty and vacant? And which is it? They want the space leased, or they wouldn't be talking with you. So don't think that because it's ABC Realty, which has 500 offices nationwide and owns a bazillion dollars worth of rental space, that somehow ABC Realty has got the advantage. They may or may not. Do they want to get the space leased or not? Well, yeah, that's what they do. So don't assume that just because you're just a little guy, that you don't have any bargaining strength. You may, just for that very reason, that they want to get it released. There's an old saying, you may have heard this if you're a law student: if you have the law, argue the law. If you have the facts, argue the facts. If you have neither, just argue real loud. As a general matter, there is some validity to that idea that sometimes you just simply have to use whatever it is you have and say it again and again and again. Whatever might be the something that you have on your side that is of value. It can't just be anything. It's got to be something that has some value, but that may be worth talking about a lot. Recognize too and explain to the other side that the alleged or apparent weaker position may be a result of circumstances beyond the party's control. It's not anything I'm doing. It's just that there are these regulations, for instance, that might impact this, that put a burden on me that you don't have. And so I'll deal with that on my own. That's for me to deal with, but you're not going to push me into something just because I have to deal with that. I'll deal with that when I have to deal with that, but that's for me to deal with, not for you. couple of other final notes. Are the norms of bargaining communities, negotiating communities do they have any validity? I've alluded to this a number of times. And the answer is quite frankly, yes. These norms that I'm talking about, and these are norms of any bargaining or negotiating community, there's validity to them only in this sense. You have to deal with them, whether you want to or not, whether you think they're legitimate or not, whether you like them or not. If there were certain norms, again, is the norm that the lessee always starts the process? If that's the norm and you're representing a lessee, or you are in fact a lessee, you are going to have to start the process. And what do I mean by that? I mean, you're going to have to make the first proposal. If the norm is that the lessor of a piece of real estate normally makes the first proposal, then if you represent the lessor, you're going to have to do it, whether you want to or not. Is there some validity to that? Well, yeah, there is, because it gives people a place to start, for instance, and it does guide the process to some extent. If it's well known that you never call the other side on a Saturday or Sunday, for instance, then don't call them on Saturday or Sunday. If that's part of the deal, then don't do it. Don't do it. Why? Because you're going to put yourself at a disadvantage by violating these unwritten rules, and you don't want to harm your client or yourself in that way. Deal within those, norms, those bargaining norms. There's a second reason, though, and that is that these norms do, to some extent, and not completely, but to some extent, do imply a methodology for arriving at a fair and reasonable, let's say reasonable instead of fair, a fair or just outcome to the negotiation. Those norms are there for a reason, probably because parties over time have found them to be useful. It doesn't mean they're perfect. It doesn't mean they can't ever be violated. But it does mean that there's something that you should consider. If you know about them, you should consider them and take them into account as you're thinking about whether you're going to violate them or not. Last thing, what about your client in terms of their sophistication? Are sophisticated clients better or unsophisticated clients better? Well, that all depends on the circumstances. Again, that's something you'll have to think about carefully, and that you'll have to come to understand your client's needs carefully. I will say this, less sophisticated clients, more often in my experience than more sophisticated clients, tend to perceive cooperation as weakness. More sophisticated clients generally tend to understand that if you're going to get a deal done, you have to do some cooperating at some point. Less sophisticated clients, particularly, less educated clients, want their attorney to be on their side, and if their attorney isn't just being just a barbarian about it, then their attorney is not fighting for them. And what most lawyers know, what most lawyers will tell you, is that's just not how it works more often than not. So you have to educate your client a little bit about that. The downside to having sophisticated clients, however, is that they don't listen to their lawyers as often, I think, as less sophisticated clients. Again, my experience is that less sophisticated clients, and I mean, by sophisticated, I mean users of the legal system. I don't mean stupid. I'm not equating that to education or to innate intelligence. I'm talking about people who have an understanding of the legal system. Those who have had experience with the legal system on a regular basis, sophisticated users of the legal system, either in litigation or elsewhere, sometimes they tend to think they know just as well as the lawyer, and sometimes they do, but oftentimes they don't. And that can be an impediment, ironically, as much as a help. Whereas less sophisticated users often really do trust their lawyer to tell them the legal stuff, and to understand the legal stuff, and to know the legal stuff. And they tend to rely on the lawyer to give them the proper understanding. And so they may actually be a little bit better about relying on you and leaning on you for those things. that gets us through chapters 1 and 2. I know that was very long. I thank you for hanging with me. And I look forward to receiving responses on these 2 chapters.